A very warm welcome to all the members here. You know the purpose of today's event. The topic is highly sensitive, burning, controversial, but still current. Therefore, it is our duty to have an elaborate discussion on this. Why it is significant is all of you know that judiciary is considered as the strongest of all the three pillars of any democracy. Ultimate words come or rather fall from the mouth of the judiciary, that is taken as the law, as the constitution. Therefore, it occupies a very, very potential and a significant role in the functioning of any democracy. Therefore, greater attention is to be paid over the composition, the constitution, and the functioning of the court system. The courts are nothing but the combination of lawyers and judges, all of you know. Justice V.R. Krishna Iyer famously said once, whether the court is a cathedral or a casino entirely depends upon the personality of the judge. Therefore, it is quite obvious that the functioning of the court is normally understood with reference to the presiding officer, namely the judge. Now we are here today to have some discussion on the appointment of those judges, the process of selection as well as the process of empanelment, nomination, and ultimately the government at the level of the president considering and issuing the warrant of appointment. So what we experience today is that unlike what our founding fathers at the time when the constitution was framed intended, we find a stark difference between the two. What our founding fathers intended was something different, but through the judicial process of interpretation, what we have today is something different. Since 1992, the Collegium system was put in place through a judicial pronouncement by the Supreme Court. And now almost how many years now? More than 30 years we have experienced how it is functioning. The functioning is not up to our expectation over the years. Probably at the beginning it was good, but gradually it is not up to our expectation. There are several factors which are coming in, and one of the foremost thing is the selection process. How they choose the candidates for judgeship from the community of lawyers. That is the subject matter of today's discussion. I don't want to much elaborate on that. We have three eminent men who are to lead the discussion. And I invite everybody to come and participate and convey your ideas. Just open your minds, whatever you think over the system that is prevalent now. It is quite disappointing to see that the number of seniors present is abominably low. It is something seriously disturbing us and disappointing us. At the same time, quite happy to see the young minds, young people who are here. The future of the judiciary is in your hands. Therefore, it is good that you young people discuss on that much more than the vanishing seniors. Fortunately, at the same time, there are three respected senior counsels here and who are, I'm sure, will lead us on the topic. Don't feel shy to express your views. We are on a discussion. Therefore, the views that are pro and con should be placed so that we will understand which one is better, and whatever amendments that would be possible in the present system, we can certainly suggest to the authorities concerned. Thank you, senior advocates, Mr. T.S.R. Venkatramana, Mr. Meenakshi Sundaram, and Mr. Balasundaram, and Jesse Jeevapriya, as well as Rajkumar, for sharing their views. Mr. Venkatramana started with the query, what is the purpose of this meet at this moment? It was very brilliantly answered by the two subsequent speakers, Mr. Meenakshi Sundaram and Mr. Balasundaram, what is the need for this meeting at this crucial hour. If not the bar, who else can discuss about all these things? It is the bar which alone can discuss about it. And I'm grateful that all the speakers invariably were consistent in their views regarding the deteriorating functioning of the Collegium system, the lack of transparency, the non-consultation with the bar leaders, and whether merit means academic merit alone to make a good judge, or other qualifications and qualities are also to be considered. Mr. Venkatramana very beautifully brought us back the history during the time when Markandeya Kadju was our Chief Justice. In fact, we all witnessed that he gathered the list of candidates from multiple senior advocates, and those whose names were found common in many lists were considered, and thereby almost 17 judges came to be appointed. Invariably, all proved to be very good judges. The credit goes actually to Justice Markandeya Kadju, but the successors slowly departed from that system. Earlier also, there was no such system. It was actually the invention of Markandeya Kadju, but we could have continued the system later, but for reasons best known to the people who subsequently held office as Chief Justices, they did not follow that system. You all heard extensively all the speakers, and I would just conclude by culling out the essential features of their speeches. First and foremost, everybody agrees that bar is the main stakeholder in the judicial system. It is the bar who is representing the entire society and the country before the court. Therefore, keeping the bar away in the selection process of judges is not a good idea. Venkatramana sir beautifully said the second principle of natural justice, nemo debet esse judex sua impropria causa, that no one shall be the judge of his own cause. But what happens is judges select judges. This is the unique situation that is prevalent only in this country. In no other country we have the system of judges appointing judges. Anyhow, when judges make judges, why the bar is not taken into confidence is the biggest question. The judges, when they select judges, judges are not going to be the litigants before them. They may not need much justice from the selected judges. But who is the main stakeholder is the bar. Bar again not for itself, but for the whole of the society. Therefore, bar is the bridge between the community and the court. The most essential bridge. Therefore, the bar should never be ignored in the process of selection. Why the Collegium judges are scared of consulting the bar? Anyhow, we don't request that as Justice Markandeya Kadju had the guts to ask for lists of candidates. Let us not expect that. At least when they have some candidates in their mind, why they don't come out taking the views of the leaders of the bar? I don't say leaders of the bar mean that the people who are elected as presidents and secretaries of the bar. What I mean is the people who are renowned senior advocates. Why you don't consult them? Why you feel scared or afraid of them? That's the whole question. This pushes us to the impression there is something which is opaque, not transparent. There may be chances for favoritism, nepotism, relatives are selected, juniors getting selected. All these talks arise because you keep the bar away. Let the bar be included in the process, not in the Collegium, but at least an informal consultation with the bar is very much essential. Secondly, when these three judges, who are the senior most judges, one obviously is from the states outside. He may not have much physical knowledge or experience with the people here. Number two and number three would... All the three are outside. Yes, at times all the three outside because of the transfer system. Secondly, even assuming that the number two and number three are insiders, they have their own allocated portfolios. And a few advocates or a set of advocates only regularly appear before them. They may know about only those lawyers, not about the other lawyers. Suppose the 2 and 3 happen to sit on the rich side or on the company side, they may not have any idea about the practitioners on other portfolios. How do they know personally? They do not know. Therefore, the consultative process should be extended to other judges also, other senior judges also. When you are considering a lawyer for conferment of senior status, you have the full court. You want all the judges of the court should sit together and vote for them. And they say that there must be 2/3 majority for that. Even to make a lawyer a senior lawyer. But how more important is to make them judges? Why do you confine only with the 3? 3, 1 may not have much knowledge about the people. 2 and 3 may not have that much experience in all the varieties of fields. Only when you take the bar into confidence, the leaders of the bar, the senior members of the bar into confidence, you will have right ideas about the persons. The third thing is, even assuming those 2 judges may have some good knowledge about the lawyers whom they recommend, they know them only as lawyers. They do not know them as the citizens of this country, so a member in the society. What about their humane approach? What about their contribution to the civil society? And what is even their contribution to the bar? Very often we come across candidates who being selected who have no association at all even with the bar associations. How do you expect them to serve the bar, serve the society? What they do, they get up early in the morning, squat in the office, read the papers, collect the money from the clients, come to the court, argue their own cases, go back to the chambers, sit there and go back home, making money. Do you want these kind of people to be appointed as judges? They will continue to be selfish. They have no social outlook, no intent, no tendency to serve the society, even to the bar. What is their contribution to the bar? Have they ever contributed one single book to the library? Have they given any good idea to any member of the bar? Have they led any agitation for the right causes? They are people who are selfish. And you say that they are very disciplined, decent guys. That's a wrong impression. It's a fallacy. People who are in the forefront in any agitation, in any good cause, they should be chosen as the judges. The judges who are number 1, 2 and 3 may not have much idea about that. In fact, if you look at the freedom struggle, 5 people actually led the freedom struggle. At the end, of the 5, except Abdul Kalam Azad, the other 4 people were lawyers. It is the lawyers who fought against the mighty British Empire and got us freedom. The moment freedom is obtained, the 20 key people who were instrumental in the framing of the Constitution, 17 were lawyers. It is the lawyers who got freedom. It is the lawyers who made the Constitution for us. But when the Constitution is put into operation, you have a system of Collegium. You simply sideline the bar, the lawyers. That's not good. It is they who actually got freedom, and it is they who made the Constitution. You can't afford to keep the lawyers outside at any point of time. People who have the tendency to get into the society, to fight for the society, to indulge in causes of the society should be given priority. Merit does not mean academic merit alone. If a person is a brilliant lawyer who comes with all kinds of preparation, with the ammunition of citations, this and that, let them continue as lawyers. They are selfish. Let them continue as brilliant lawyers. Why do they want to sit as judges? We can't get justice at all from them. We don't want philosophical judgments. Nowadays, if you look at the judgments, every judgment looks like a thesis. Who wants it? At the end of the day, the judgments are for the litigant public. Most of the judgments can't be understood by the public. It needs, again, an expert lawyer to understand what these judges are trying to say in the judgments. Lord Denning beautifully said that if a common man is not able to understand your judgment, you have failed as a judge. He says, if a man wants to refer to the dictionary to understand your judgment, you have twice failed as a judge. Today, unfortunately, we have majority of the judges who are delivering this kind of thesis like judgments, which even lawyers find it difficult to understand. This is the situation. This kind of academic merit is irrelevant. Maybe good, but persons who are not only academically meritorious, but who have their pet corner for the society's interest, that is also to be taken into account. That would be possible only when the bar is taken into confidence in the selection process. Secondly, the representation. From ever since the constitution was put into operation till date, we have the higher judiciary always dominated by the upper caste people, no doubt. This is an admitted fact. But we say very firmly, their quality is immeasurably high. They do extremely well. There is no qualms over that. They are excellent judges. They are proved to be excellent judges right from the beginning till date, beyond comparison. But India does not belong to them only. India belongs to everybody. The meritorious as well as the non-meritorious. In the sense academically I am saying, people who are highly qualified with the London education and university degrees, and the people who got educated in the corporation schools and in government colleges, they are all entitled for that. We, fortunately or unfortunately, we have the classification with reference to our constitution only on two grounds, educationally and socially backward. We have the historical suppression for certain communities who are not provided with good opportunities of education and social advancement. They should be chosen. Therefore, India belongs to everybody. The judiciary cannot take a sidewalk and say, yes, India belongs to everybody, but not the judiciary. Judiciary also equally belongs to everybody. Therefore, the people should have the faith in the system. Everybody has a representation. Therefore, it is high time the collegium system or whatever system, they should have an overview what kind of representation we have now. The judiciary, our demand is that the judiciary must have adequate representation for each and every unrepresented community in this country. So also women. Jesse made a very valid point. Women have their own difficulties. They cannot fly or shuffle between Chennai, Delhi and Madurai, just like men. Therefore, we are least known to outside world. We have our own family arrangement, we have our own family inhibitions here. Therefore, we appear only here in Madurai. But who is there to take our candidature to somewhere outside to Chennai, where the three top judges are sitting? It's a valid point. Why they are not giving much importance to women? Why there is no representation for women? That's also a very important facet to be addressed. The three judges don't come and sit here. Maybe they come for a visit occasionally. Once in 3 months they sit for a few days. That's not sufficient. Therefore, the bar alone can function as the bridge to carry the good candidates to the knowledge of the people in the collegium. And if the collegium is sitting with a tight fist, we will not consult anybody, how to carry? They treat the bar as an alien. That's not at all a good idea. How to represent about the good people here in the Madurai bench and bring to the knowledge of the judges who are sitting in Chennai? Only bar can do this. Therefore, I would respectfully place three things for the general body's consideration. Number one, in the collegium system, the consultative process should be enlarged to the other senior judges first, that is apart from the collegium. When senior advocates designation involves a process like a 10 judges committee considering them, recommending them, and full court voting for them, I feel it is far more important to have the judges selected with such a kind of consultative process, maybe formal or informal. Therefore, the consultative process should be expanded to the other judges and to the leaders of the bar. Not the elected leaders of the bar I am saying, but the renowned senior advocates of the bar. This is number one. Second is, the system of selection of candidates should be made more transparent. We don't doubt the integrity of the collegium judges. What we say is that because you make the system so opaque and so dark, it gives room for all kinds of suspicion regarding nepotism and favoritism. Make it transparent. Let us know who are the candidates who are to be considered by you. Complaints may come, but we are in a democracy. You will have to consider everything. Therefore, the system should be made more transparent. Third is, merit alone. Merit shall not be counted only on the academic side of the merit. It should be a combination of several things. Very rightly pointed out by Mr. Meenakshi Sundara by citing the Supreme Court judgment. The Supreme Court is emphasizing the triple test, the triple qualification: ability, independence, and courage. Ability means that ability to dispense justice, not to argue cases. At times we find that judges start arguing with this. Ability to decide, the power to decide. Secondly, they should be absolutely independent. And some of the judges, I am told that his junior should not appear in the court. And the people who are known and who are friendly with them and they were attending parties earlier should not come to his court. That is a sign of their lack of independence. When a junior comes before you, what's your problem? You look at the case. When you have the trepidation that, oh, my junior is here, somebody will talk ill of me, that there you lose that independence on that moment itself. We want judges who are absolutely independent. And courage, that's very important. You look at the opposite side, the government or the central government or somebody, then your trepidation starts. Why? That most essential quality is courage, the boldness. I used to say very often the famous statement by the long-time Chief Justice of the United States of America, Warren Burger, when somebody asked him, what kind of people you would like to have as judges? His immediate answer was, we would like to have gentlemen as judges, with sterner hearts. And of course, a little knowledge of law may not be of much harm. That is what they want. We want people who are gentle, who are humane, and who are courageous. Krishna Iyer used to say the three words very beautifully. The quality of judges: intelligence, integrity, and intrepidity. Intelligence, as all of you know, a person who is knowledgeable enough will turn to be intelligent. Integrity is a character which is born. He must be upright, independent, unbiased. Intrepidity, that is absolute courage, fearlessness. Whoever be the respondent, whoever be the petitioner, the power to decide independently. That is the most essential quality. Therefore, merit shall be assessed with the combination of all these triple things: ability, independence, and courage, intelligence, integrity, and intrepidity otherwise. The last thing is that representation for each one of the communities, including the gender reservation, namely women should also be given the priority. And I hope that these three things which I placed before you will get the approval of the general body, and as the senior members suggested, we will prepare a draft, again place it before you in the notice board, and we will send it to all the authorities concerned that the system should be made an expanded consultative process, more transparent, more representative, and mainly taking the bar into confidence in all these matters. Thank you so much.
Thank you for so eloquently summarizing today's session. The President of MMBA, Senior Advocate Isaac Mohanlal. Thank you also to all of our dear members for attending today's session, the colloquium on the Collegium and the present trend.